Hello, hello, hello. Press 1 in the chat if you can hear me. Hear me, can you hear me? Da 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 da, can you hear me? Pressing 1 in the chat if you can hear me. Da 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 da. Hello, Cool Gamer. Hello, Teresa. Hello, Rosemary. There is NC the Fly. NC the Flea. All right, so I am going to start by doing this top subscriber thing. What I'm going to do when you guys come in every Friday, I'm doing this like once a week. So from Friday to Friday, you will be the top subscriber for the week. You know what I mean? So what I do is I'm going to write your names down every Friday when I go live and write your names down. And I will rip them up and put them in a bucket or a hat or whatever, mix it up, and I'm going to pull out a name, and that's when you are going to be the top subscriber of the week. I think it's fun. I think it'd be pretty cool. Things like that. So, we are going to do the final part of the Edward Covington case. What we're going to do is scatter through some court. They have some things on YouTube when he was sitting in court. I couldn't find the full court cases. I mean, I can try. I put Edward Covington court in it, and nothing has pulled up. So his court was 7 years ago. It looks like 8 or 7 years ago. So, I don't know. So I'm been trying to look for it. Maybe it's on here. We'll find it. We'll just go through some of these things. Yeah, so it's been a while ago, so maybe they don't have like the full blown of things. So I'm gonna share my screen. There we are. There we are. If you can still hear me, that's perfectly great. So we are gonna start. Let's see. We are gonna come accuse the murder Lisa Freemer and her children asked to be dismissed from high. Okay. He's guilty to triple murder. Trigger warning. Let me put this up so you guys. Trigger warning. If this is too much, you can leave. I would understand. And make sure you put your headphones in. Put your headphones in if you can't hear. Or your AirPods or whatever. So this is what all comes up when I look for it anyways. So we're gonna do, what's this? I don't like the ones with the news for some reason. October 13th, 7 years ago when it started. He looks different. All right, let's try this. It says, warning, unedited testimony, graphic details, crime, spree, child, murder victim, mother testifies. Is this it? This ain't it, guys. Sorry. That is not it. Go down more, see if there's any more. Okay. Well, we'll just go from the ones we know. Okay. All right, let's do this.
Another heartbreaking day in court at the Edward Covington triple murder trial. Today, a gut-wrenching confession from Covington was played in court. Our John Thomas has been in court all morning. He joins us now live. And John,
see, I hate when they do this because I don't like when the news. Okay.
testimony was so graphic today during Edward Covington's murder trial. The victim's family and friends had to leave the courtroom. Covington pleaded guilty to killing Lisa Freiberg and her two children back in 2008. News Channel's Jeff Patterson is at the courthouse. And Jeff, what has been happening here?
Yeah, good evening, Gail. Very, very difficult to listen to testimony today inside of the court.
All right, well, we're not going to do this because this just pissed me off. So we'll just do this one. The Supreme Court. We'll do the Supreme Court. Okay. It says Covington plea. Well, it says 3/9/22 Florida Supreme Court oral arguments. Edward Allen Covington versus State of Florida. SC 211077. Edward Allen Covington versus Ricky D. Dixon. Covington pleaded guilty to first-degree murders of Lisa Freiberg and her two children, 7-year-old Zachary and 2-year-old Heather Savannah. The three were beaten and fatally stabbed in 2008. The trial court sentenced him to death, and the court affirmed the convictions and death sentence on direct appeal. Covington's filed a post-conviction challenge in the trial court, raising several issues he claims were denied and the appeal followed. Covington has also filed a habeas corpus petition. All right, here we go.
All right. Hear ye. Supreme Court of Florida is now in session. All we have cause to plead. Draw near. Give attention. Shall be heard. God save the United States.
Great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. We'll now take up the case of Covington versus the state of Florida. Counsel.
Good morning, and may it please the court. My name is Courtney Hackett, and along with co-counsel, I represent Edward Covington, one of the most profoundly mentally ill people on death row. This case comes before this court on appeal from the circuit court's denial of Mr. Covington's post-conviction motion after an evidentiary hearing was held. Mr. Covington's convictions and death sentences should be vacated because the capital conduct was committed by a man who struggled with serious mental illness his entire life, the full extent of which was neither presented to nor understood by the trial court due to trial counsel's ineffectiveness. We understand that
Counsel, I understand that Mr. Covington's got some serious problems, but doesn't the record reflect that most of his problems were the result of abuse of cocaine and alcohol, and that he would engage in behaviors, basically out of control sort of behaviors that were triggered by that abuse, and that he knew it, and that he did it anyway?
Your Honor, that is part of the issue with trial counsel's ineffectiveness in presenting and developing the mitigation. The sentencer's order reflects a completely inaccurate understanding of Mr. Covington's use of cocaine and alcohol. The sentencer characterizes it as voluntary, and while yes, Mr. Covington did ingest those substances, quote unquote, knowing it would cause rage, his alcohol and substance abuse were the product of his mental illness, not an entirely volitional choice.
Help us understand the rule you're asking us to adopt then when someone ingests an illegal substance and it has a mood altering or behavior altering effect, and how you propose this court deal with, the voluntary choice of an individual. You said quote unquote voluntary. Help me remove the scare quotes. When are we supposed to say, okay, this wasn't a voluntary act?
Your Honor, had this properly been presented to the sentencer as a product of his mental illness, as polysubstance abuse that was driven by his mental illness rather than an entirely volitional choice, it would have been better understood by the sentencer rather than being used as a non-statutory aggravator to demote the mental health mitigators. And so, Your Honors, what we're asking for is that Mr. Covington's death sentences be vacated because the sentencer's order reflected a misunderstanding of that alcohol and substance abuse. Had Mr. Covington not pled guilty and waived jury, had he not pled guilty, he would have presented an insanity defense, which would not have been negated by the alcohol and cocaine use. There were numerous times throughout his life where he was stabilized when he was receiving the proper medications. However, after failed attempts at getting those medications and getting stabilized, he engaged in self-medication with those substances in an effort to sort of stabilize his own mind when he wasn't receiving the proper mood stabilizers.
Could you elaborate, though? I mean, given what the record shows about what counsel knew from the various experts they had consulted with, I think it was up to 17 possibly, or at least 7 or something, only one of whom would have testified about the defendant having been insane at the time of the crime. I mean, what would the rule be to say that under those circumstances that it's not a reasonable choice for a lawyer who is presenting, obviously, strong mitigating evidence on, the 2 statutory mitigators and all that. But I mean, what would the rule be that we would say that a lawyer faced with that information from the experts had acted, below the level of reasonableness, which, as you know, is a pretty deferential test? I mean, how could we possibly say that didn't rise to, that's effectively the same as not even having had a lawyer?
Well, Your Honor, First, there were 17 or so experts that were consulted by trial counsel. However, not all of them were consulted for an insanity opinion. Not all of them were consulted for the mental health mitigators. The ones who were consulted and did testified to the existence of both statutory mental health mitigators. However, those statutory mitigators were demoted as a result of the sentencers finding that the drugs and alcohol factored into that.
Didn't the trial judge's order give, I can't remember which label, but it was significant weight to the mitigator, wasn't it?
The sentencer found that Mr. Covington suffered from bipolar disorder and gave that great weight. And with regard to the two statutory mitigators, those were given moderate weight. However, trial counsel was operating under a misunderstanding of the law in failing to present the testimony of Dr. Valerie McLean, who was ready and willing to opine that Mr. Covington was insane at the time of the offense.
Well, but the problem with that is you got all these other people that said that it wasn't. So you kind of going down to a path where the refutation is going to come very aggressively and overwhelmingly. Am I wrong?
Your Honor, trial counsel should have at least attempted to present insanity at the time of the offense during the penalty phase.
The counsel, she testified, I believe, at the post-conviction, or it was there, that she was worried about opening the door, correct? I mean, there were 4 state experts that would have testified that he was not insane, and the trial judge had found them credible. So, I mean, what is the likelihood that, well, A, how is that ineffective when there was a clear strategic reason for not putting that on there? And then what would prejudice would have? It seems like it would have been perhaps prejudicial to present that when you had 4 experts willing to say that he wasn't insane.
Trial counsel had significant support from the mental health experts that did testify, again, with regard to the mental health mitigators. Additionally, Dr. Kropp had been on the fence about insanity leading up to the trial. Again, counsel was operating under a misunderstanding of the law with regard to the presentation of insanity, even though it could have, yes, opened the door to the state experts refuting what Dr. McLean stated, given her opinion on insanity. There was substantial other information regarding Mr. Covington's mental health, and the prejudice lies in the fact that the insanity, had it been presented by Dr. McLean, would have lent more support to finding greater weight on the statutory mental health mitigators. There can be no more compelling evidence than that someone is insane at the time of the offense. It's beyond just substantial impairment. Insanity reflects a complete absence of reason, the ability to reason. And so the prejudice lies in the fact that the sentencer did not hear that Mr. Covington was insane. And as a result, those 2 statutory mental health mitigators were demoted in weight. Also factoring into that were the drugs and alcohol, which do not negate insanity. In some cases, they can bolster it. When you're having that interaction between a mental illness to the extent that Mr. Covington was suffering, the lack of stabilization on the medications, the stressors, and the polysubstance abuse, insanity at the time of the offense would have been incredibly mitigating.
In light of the statute that says that voluntary intoxication is not a defense to a criminal act, do you have any cases that say that it is that the finder of fact can find someone to be insane while they are under the influence of substances that they've voluntarily taken?
Your Honor, I believe it is in Code v. State of Florida, 946 Southern 2nd, 988. There was evidence supporting a statutory mitigating circumstance that the defendant was unable to conform his conduct to the requirements of the law, and part of that involved the ingestion of drugs and alcohol.
But that's not a case where the person was found to be not criminally responsible for their acts. So it's not correct?
Correct, Your Honor. But there's nothing saying that it could not have been presented in the sentencing phase.
Are you suggesting that the evidence is such that no reasonable trier of fact could have found counsel's decision to be reasonable trial strategy?
Yes, Your Honor.
Okay.
I believe that evidence of insanity at the time of the offense, if it had been presented during the guilt phase, had a likelihood of success and would have resulted in a finding of not guilty by reason of mental insanity. Instead, counsel neglected to present that during the sentencing phase. So even though Mr. Covington waived all defenses to the guilt phase, he didn't waive the presentation of mitigation or this highly compelling information that he was insane at the time of the offense.
I think you're down to 3 minutes.
So, Your Honors, we are just asking that Mr. Covington's convictions and death sentences be vacated because these horrific facts, if nothing, lend support that these offenses were committed by a man who was seriously mentally disturbed to the extent of insanity. And that information should have been presented to his sentencer. It could have affected the outcome of weighing the aggravators against the mitigators. This is a highly aggravated case. However, it is not the least mitigated case. There is substantial mitigation present. The presentation of insanity at the time of the offense, along with presenting the alcohol and substance abuse as a separate mitigating factor itself, could have altered the weighing of the aggravators and mitigators. Mr. Covington is a member of a class of individuals who is seriously mentally ill. He has reduced culpability. His case is not one that involves a situation where there is no mitigation. Yes, it is truly horrific. However, Mr. Covington he accomplished substantial achievements when he was stabilized. It is not as though he committed horrific offenses his entire life. He suffered a massive psychotic break as the product of his serious mental illness, polydrug interaction, numerous neurodevelopmental complications, which also could have gotten greater weight had those been presented in more of a context. So there was substantial mitigation. Mr. Covington is more than the worst thing he's ever done. And we are asking that you vacate his conviction and sentence of death. And if there are no further questions, I will resolve.
Just to clarify, you've
Yes,
said twice now that you're asking us to vacate the conviction. You're just talking, but the remedy here would just be related to the sentence, right?
Yes, Your Honor, that's correct. And I will reserve the remainder of my time for rebuttal.
So, like I said in the side chat, is that she is pretty much saying that he didn't have a fair trial at the trial, and that she wants to vacate to make everything to go straight to death row. So he didn't have like a fair trial when it came to his mental health and his drug problem. At that time, when he was interviewing with the, with the detectives sitting in the rooms, he was coming off crack cocaine. He was overdoing his medication. He wasn't taking his medication right, and that he was coming off the mental medication. And when you come off of mental medicine, any antidepressants or anything, you actually go through this withdrawal. Now, for myself, when I got off drugs, my mental state wasn't all perfect at all. So that's pretty much what she's doing is chopping down the whole thing into like 4 segments on what they want to do with him. He's been in there since 2008, so now it's 2021 of March when this was going, and she had to go in front of the Supreme Court of 6 judges to go to every judge to figure out what they can do with him on death row, to back his date up or make it faster, because he's playing the insanity card. And when he was sitting there and with the detectives, if you notice, he teared up a few times, but like he was completely calm when talking about it. He remembered everything else, but didn't remember the whole what he did to the family, the girlfriend and the 2 kids and the dog. So we all see here what she is trying to do for Edward. So here we go.
Good morning. May it please the court. My name is Marilyn Becue and I represent the state of Florida. I'd like to focus the court's attention on the procedural posture of this case. The issue before the court is whether counsel was ineffective in representing Mr. Covington. Mr. Covington had not just effective assistance of counsel, he had exemplary assistance of counsel. He was represented by a team of attorneys who among them had decades of criminal trial experience. Ms. James and Ms. Holt, who is the elected public defender of the 13th Judicial Circuit, had decades of capital litigation experience between them, all facets of capital litigation, trial litigation, appellate litigation, and post-conviction litigation. They were very clear-eyed about the challenges that Mr. Covington's case presented. He was accused of and admitted to the brutal murder of a mother and her 2 young children. He was found hiding in the closet where the dismembered and decapitated body of 2-year-old Heather Savannah was found, where the mutilated body of her brother, 7-year-old Zachary, was found, where the badly beaten and eviscerated body of their mother, Lisa, was found. Even the family dog didn't escape Mr. Covington's violence that day. Duke was found dead, bludgeoned to death in Heather Savannah's bedroom. Nonetheless, over the 6 years that they represented Mr. Covington prior to trial, they fully investigated his mental health issues. They discovered that he had a long-standing mental health disorder, bipolar disorder, that he had intermittent explosive disorder, and he suffered from polysubstance abuse disorders. They consulted with no less than 17 different experts, 7 of which testified at the penalty phase. Of those experts, only one, Dr. McLean, was willing to testify that Mr. Covington was insane at the time of the offense. Nonetheless, they were willing, despite the long odds, to go ahead with an affirmative defense of insanity during the guilt phase of the trial. As this court knows, shortly after the trial commenced, Mr. Covington became agitated. A recess was taken. He had conference with his attorneys, spoke with his parents. The judge ordered a competency evaluation. The next day, Mr. Covington came in, pled guilty to all of the charges against him, and waived a penalty phase jury. The defense presented 7 of their 17 experts at the penalty phase. They all discussed Mr. Covington's longstanding bipolar disorder, his efforts to obtain help, and how the cocaine and alcohol abuse was a comorbidity of his bipolar disorder. And the sentencing court did find that he suffered from cocaine and alcohol abuse, and he gave that mitigator great weight. He combined it with the bipolar disorder and the intermittent explosive disorder. So he found those mitigators and gave them great weight. This was not a case where there was information that was later discovered during a post-conviction proceeding that was not presented at the penalty phase. The complaint seems to be that Dr. McLean just didn't utter the words insanity. Ms. James and Ms. Holt both testified, number one, they didn't think it was inappropriate to raise an affirmative defense of insanity during the penalty phase. Now, Mr. Covington isn't challenging his plea here, so he's not indicating that for some reason that they should have raised insanity for purposes of challenging his plea. But they did talk about all the same underlying mental health issues and disorders that Mr. Covington has suffered from his entire life to support the mental health mitigation. The judge did find both of those mitigators and gave them moderate weight. Well, let me step back there. He found the inability to conform his conduct to the law was impaired, but not substantially so because of his voluntary use of alcohol and cocaine.
It diminished.
Correct. It was diminished. Now, that was something they weren't going to be able to avoid because Mr. Covington did speak of it during his statement to the police that how, particularly with alcohol, he knew he had a rage reaction. He also talked about throughout his entire life, his moods were kind of like an on and off switch. This was not, although this was a horrific act on Mr. Covington's part, it's not fair to say that he has no history of any kind of violence. The defense knew that he had a history of perpetrating abuse on his sister. He had some other instances with his ex-wife. None of this was focused on at the penalty phase as any kind of aggravator. Instead, it was discussed in relation to his various mental health issues. There was little that was not discussed about Mr. Covington. I agree, he has a history of mental disorders. He has bipolar disorder. He has intermittent explosive disorder. I can't disagree with the court's findings in that regard. They were determined by the court and they were given weight that the court felt was appropriate.
I'm sorry to interrupt you here, but is it fair to say that the testimony from defense counsel at the post-conviction hearing reflected some maybe confusion or muddled thinking about sort of the difference between insanity as an affirmative defense versus just arguing insanity as a non-statutory mitigator?
I would not agree with that. I think they were very clear on the distinction between an affirmative defense of insanity and the mental health mitigation. They also knew that had Dr. McLean testified at the penalty phase that Mr. Covington was insane, the state would have cross-examined Dr. Rao and Dr. Kropp, both defense experts who were going to testify and did testify at the penalty phase, about their opinions that he was not insane. And of course, the state also had two experts lined up who were going to testify that he was not insane. There were other experts who had the same opinion that Mr. Covington wasn't insane. He was evaluated for competency. He was evaluated after he filed his notice of intent to rely on insanity by Dr. Mayer and Dr. Taylor. They both found that he was not insane. So the post-conviction court found that even if it were an available mitigating circumstance, it was a reasonable tactical decision for the defense to not take that extra step to go to the word insane and rely instead on the substantial mitigation that they did rely on, the mental health mitigation, because they knew that if they had opened that door that the state was going to walk right through it. Now, this case had been litigated for 6 years prior to this all commencing, so there weren't a lot of secrets between the state and the defense. Obviously, they had notified the defense they were going to pursue insanity. He was evaluated by state experts, information was exchanged. So they were pretty aware of where the state would have went had they tried to introduce insanity. And frankly, it's potentially would have been objected to, but at this point, we don't know because it wasn't introduced at the penalty phase.
Can you maybe tell us
Sure. The defense did move the court to introduce mental health evidence short of insanity at the guilt phase. So in other words, a diminished capacity type of defense. That was litigated. That was denied. And they, excuse me, obviously did the notice of intent to rely on insanity. Depositions were taken. The state took the depositions of, I believe, I believe Dr. McLean, Dr. Kropp, Dr. Rao, possibly Dr. Saw, who was the doctor who evaluated Mr. Covington at the hospital meeting the day after these events, and evaluated him for a Baker Act. I believe the state also took the deposition of, his name escapes me now, but the doctor who had treated Mr. Covington after the incident with his ex-wife and the cat mutilation incident that they had presented as evidence of his history of a longstanding mental health disorder. So it was fairly well litigated throughout the, it was obvious to both the state and the defense where we were going with this case because of the horrific nature of the facts, and Mr. Covington's ingestion of Tylenol, aspirin, and his Seroquel after the fact, that the issue was going to be what his mental status was when he committed these horrific crimes. The sentencing court issued a very lengthy and thoughtful order, understood the distinctions between the mental health disorders and the voluntary use of cocaine and alcohol. This was a very experienced judge who heard all of the evidence. He was not under any misconceptions about the significance of the mental health mitigation that was presented in this case. I don't recall, and I apologize if counsel discussed the antisocial personality disorder issue, but I just wanted to inform the court that this trial judge, as evidence of the fact that he understood the distinctions here, specifically noted in his sentencing order that he was not considering that as an aggravator. He understood that can't be used as an aggravator, and it was introduced merely to rebut the testimony of the bipolar disorder, which obviously he found existed and gave great weight. I would urge this court to affirm the post-conviction court's order denying post-conviction relief in this case. Unless the court has any other questions, I'll relinquish the podium. Thank you.
Counsel, rebuttal.
Good morning. David Hendry for rebuttal. Insanity is different. This case is very different. I've been arguing before this court for about 20 years now. This is my very first insanity case. It doesn't happen all the time in these cases. Mr. Covington is mad. He is insane. It's elementary that when a man is insane at the time of the offense, you present evidence that he is insane at the time of the offense. There was no waiver here, and that's the crux issue in this case, is did Mr. Covington waive insanity at the time of the offense at the penalty phase? And if you look at that penalty phase, if you look at that plea form, which was exhibit number 20, state's exhibit, it's a very long plea form, and there is absolutely no waiver of insanity at the time of the offense at the penalty phase. So it's not knowing or intelligent at the very least. It is elementary. As a criminal defense attorney, a capital defense attorney who's very experienced, you have to present insanity at the time of the offense, because it's not just the two statutory mental health mitigators. It goes way beyond that. It's not that he wasn't playing with a full deck. He didn't have a deck.
Well, but counsel, I mean, I understand your position on this, but there's still the problem of all these experts that say he was not insane. I mean, do you dispute? You shake your head. Do you dispute that the numerous experts said that he was not insane at the time of the offense?
You start with your best foot forward. Dr. Valley McClain.
I asked you a question. Do you dispute that?
3-0. Post-conviction, 3-0. It was unrebutted that he was insane at the time of the offense. We met our burden. We presented Dr. Cunningham. We presented Dr. McLean and Dr. Wood with a PET scan that showed that this man, he has organic brain damage.
What was the count at the time that counsel was making the decision whether to characterize this as insanity, which is that's the relevant point in time, not the experts that you had at the post-conviction hearing. What was the count?
That's a red herring.
No, it isn't. What was the count?
I didn't try this case, but I will tell you this. They had at least one expert who said insane at the time of the offense. And it is disingenuous to say we were going to go to the guilt phase and present insanity at the time of the offense, and then at the penalty phase to say it's not really genuine. We only have one expert. Dr. McLean can't be believed.
So you don't know the count?
The count of...
At the time that counsel was making the decision.
I know that Dr. McLean said insane at the time of the offense. This case was very perplexing because there's absolutely no discussion whatsoever about insanity at the time of the offense in this court's direct appeal opinion. So we had to dig and dig and dig to find that opinion that he was insane at the time of the offense. And again, you start
I have to say, I'm kind of disappointed with your candor at this point. I mean, we've talked about it now in the OA.
So I'm going to say this. This video was in March of 2022. Okay. March 9th of 2022. What they're trying to do is get him the insanity plea so he can get life in prison and not the death row, because right now he's on death row. And they can just say any day to set him a date to give him the injection, because Florida is one of the states that they do death by ejection still. Or I think either one is electrocuted. I don't even know. But I didn't really look into it. I should look into it. But what they're doing is they're trying to get him the insanity plea. Like, he has a mental disorder. He has manic bipolarness. Okay. He wasn't insanity. He knew what he was doing. Okay. He knew that how he killed them and everything else. If you watch in the latest videos that I played of him sitting there calmly and talking about it, he was fine. You know what I mean? And he was trying to use that mental card, just like they're doing right now. So, but as of right now that I know, he's still on death row. Like, I don't think he got the insanity plea at all. But yeah, here we go.
Are you telling me that you don't
know what the count was or ballpark? You know that there were other experts who had been consulted at the time that counsel was making this decision.
I know that Dr. McLean opined insane at the time of the offense. And I know that there wasn't a lot of go-between between defense counsel and these mental health experts as to, you have to ask your mental health experts, was he insane at the time of the offense? And going to Justice Lawson's question about the voluntary intoxication, 3.6, there's nothing in the jury instructions that really say that if you ingest crack cocaine and alcohol, that this negates the insanity defense. Crack cocaine and alcohol would only accelerate insanity at the time of the offense. And, you know, I'm trying to be candid here. All I can say is that we had 3 experts unrebutted that said insane at the time of the offense, and open the door. As a criminal defense attorney, it's your job to try to open the door. Here's the question that this court has to ask, okay? Had defense counsel tried to present insanity at the time of the offense, and had the state objected to this evidence, and had the court prohibited this evidence, would this court then reverse that decision? Because under Hitchcock, Eddings, and Lockett, any circumstance of the offense is presentable, is admissible at a penalty phase.
Counsel, you've exhausted your time. I'll give you another 30 seconds to sum up.
Thank you. The very relevant cases here are Hardwick from the 11th Circuit and Kimmelman from the United States Supreme Court, which we cited, which basically say this: defense counsel was operating in this case under a mistake of law. They said it was inappropriate to present insanity at the time of the offense. That is wrong. Because that is wrong, this cannot be a reasonable strategic decision. This is elementary. You have to present insanity at the time of the offense in a capital case when a man's life is at stake. Thank you very much.
Thank you, counsel. We thank you all for your arguments in this case today. The next case on today's docket will be heard remotely. So that concludes this session of court.
So we do know that right now, if you look him up, he is still on death row. All right, hold on. Okay. Let's look him up real quick. Oh, this sucks. Hold on. Here we go. Edward Covington Court docket. Okay. Jesus. All right, hold on. Let me look up. Denied motion. Yeah, they denied his motion. Yep, February 2019, April, yep. Yep, denied all his motions, guys. So he's on death row still. Yep. And then just tells him the jury was picked up openly. Statements has been begun and testimony has started. The trial would halt the 3 homicides and waive jury trial. This is different from other cases. Mr. Convince is jury before him, so he is not thinking about hypocritical. After the initial brief, but if you go to the reply, there's much more because Mullins and come out after that. I don't see an issue in your last one. Okay, thank you. I would like to move on to the other issues if I could, because if this happens on top, you compare. Yeah. Well, testifies that constantly tweaking his medication for know how much you had to do that to get stabilized over 6 years. 2004, his life after a bypass. Someone named Sherry Tate was cocaine addict and was also bipolar. Oh, we already read all this. The judge doesn't tell you why he rejects those, and once he rejects the fact because the state's experts testify he is not mentally ill, lose the judge is totally and completely rejected that. Once you reject that, all the opinions crumble. The two state witnesses, he doesn't tell you why he is rejected except the seventh fact that he is mentally ill and accepted defense testimony, but is coming up with his own conclusion, and the conclusion is not found in the testimony. The confusion that he was merely diminished is not found in the testimony. He already rejected the state's witnesses, but is not accepting the defense conclusions and not telling you why. And that is why this is important, because none of this to say you should have to come to leap and say that he did consider these things when it is not there. And I am out of time. Thank you. Thank you for your arguments. Let's see. Well, that was it, guys. That was all on that case. When I pick another case, I'm gonna make sure I can find some court videos so we can watch it. The last time I did court videos, it kind of so my live that I did a couple days ago or yesterday, and it's crazy because I think it was a couple days ago, they took my video down because of terms of services guidelines, because I played the news. So it's like, oh shit. So that's it. It's based on so Rosemary is the top subscriber this week. So congratulations, Rosemary. I don't know, guys. I think the next true crime will come this Thursday, guys. Thursday or Friday, which one, if I'm not too busy. I got a lot coming up this week, so I will try to make it as soon as possible I can to tell you a different case. Please, if you are not my Facebook friend, please look me up on Man Extreme XM. And the avatar is the same here. So you can get all the latest updates and things that's what's coming up. Another thing is I'm on Twitch, Twitter, Instagram, places like that. I don't really go on a lot of social media, but I go on Facebook the most. If you like to donate to the channel, I appreciate it. My PayPal and my Cash App link is in the About section. And if you would like to get anything off my Amazon wish list, mostly it's Skylar, and then I got the paint stuff there. That would be amazing. You can play the news clips. You just need to stop every couple of minutes and commentate. Oh, okay. Yeah. Well, I'll remember that next time. I just don't want nothing to happen to this video, so that's why I didn't really play all the, the news and the court things, because I don't want it down, because this is part of the true crime. So, all right, guys, I'm going to get out of here. Thank you, Rosemary, and See the Flea, Teresa, Gwen, Cool Gamer. Thanks for coming in and stopping in and saying hello. Much appreciated. So Thursday or Friday will be the next true crime. I might be doing trivia Monday. Get back to doing things for the channel. There's a lot of good things that I want to do for the channel. So if you're here, you're here. But all right, guys, I'm going to get off. Yes, I'm going to drink water and see the flea. I start my workout Monday. So yay. I'm going to start working out Monday. But all right, I'm going to get off here. I hope everyone has a wonderful day. Be kind to yourself and others. Don't let anyone amount to your nothing. You are worth it. And thanks for stopping in. Bye.